First off, I wasn't aware he was on parole.
Mr. Fogel was released by a deal that you made. You're aware that two people.
The court is unsure of how much more extreme it gets when the prosecution continues to refuse to provide exculpatory information to the defense. I am disqualifying the entire 11th Judicial District Attorney's Office.
146 text messages between you and Mr. Fogel seems to be at ends with your email that you gave Ms. Owens. I am alleging that he's committing fraud upon the court.
Written witness statement very much appears to not have been the full truth as revealed by Detective Kruger when confronted with cell phone records. Well, then I'm going to start to have concerns that your office is now a witness in this case. Mr. Lindsay, if you'll raise your right hand, do you swear or affirm under penalty of perjury that the testimony you're about to provide this court will be the truth, the whole truth, and nothing but the truth? You can be seated. Your witness, Mr. Tellini.
Thank you. Good afternoon, Mr. Lindsay.
Good afternoon.
Did you please introduce yourself and spell your last name for the record?
Jeff Lindsay, Lindsey.
And you are currently the elected DA for this judicial district.
That's correct.
Prior to becoming the elected DA, you were a senior deputy district attorney in this judicial district.
I was in 2021.
What was the time frame that you were employed in this district as a senior deputy district attorney?
Well, I worked here from 97 to 2000 as a regular deputy district attorney. I worked, as you know, in Colorado Springs and Pueblo.
Yes.
And as a senior deputy, I was hired in February of 2021 through October of 2021.
Do you remember your last day in October 21?
I don't remember exactly what day it was. My notice was to quit the office, and I gave 4 weeks notice. I don't remember what day that was.
Okay. And one of the cases during that later time working in this judicial district, you were the district attorney assigned to a case involving Anthony Fogel.
I wasn't initially assigned to it. It was assigned to Deputy District Attorney Steve Sullivan. I believe in February. I just went back and looked at the notes, and it looks like February, Mr. Sullivan handled it. I took over Mr. Sullivan's docket when he left in the summer of 2021 and took over that case. His docket was this case was part of that docket.
Okay, but I guess I'm confused. If you had given your notice and were going to be resigning before the trial took place, why was the case then not assigned to a deputy district attorney who would be able to proceed to trial if it in fact went there?
I wasn't here in November, Mr. Tellini. I don't know. You have to ask the people that were here. I gave my notice. They got coverage. Whether or not they got coverage or there was coverage available, I don't know the answer to that question. That's not something I know. I gave notice and I left the end of October.
Well, were you prepping this case for trial?
I don't believe so. I don't have any notes on this case.
Okay.
I know there was a court appearance in October. I took one note where I made a plea offer, and that's the only one I know of. And
Well,
I shared that with you as part of the subpoena ducis tecum that you provided to me.
And the plea offer that you provided was for 8 years in the Department of Corrections.
It was a DF2, 8 years DOC. That's right.
Okay. And you're aware of the facts of 21 CR 60?
I haven't looked at the case closely since it happened. I was aware of it at some point or another because I would have made the plea offer. Again, I'm talking about something that happened about 6 years ago.
Yep.
I appeared one time in this case in October, and that's it.
But you also pled this case to a careless driving.
That's correct.
Were you aware that this case involved a handgun that was found?
At the time I made the plea offer, I probably was. Right now, I haven't read the PC affidavit or the police reports and gone back.
I'm
trying to remember what I knew at the time or what I remember about what happened then. And right now, I don't remember all the facts of the case. There was like maybe a gun thrown and maybe some drugs thrown out the window. And that's all I remember.
Mr. Tellini, I'm just going to say this to start. Same with you, Mr. Lindsay. We're going to wait till each other finishes speaking before we interrupt. Okay.
I understand.
Go ahead.
So you have some recollection that involved a gun and then involved a significant amount of methamphetamine.
All I said is I know that there was a gun involved and there were drugs thrown out the window. That's all I remember about the facts of this case. And that's after I've refreshed my memory. Before, I don't even remember this case.
Were you aware of Mr. Fogel's criminal history?
At the time I made the plea offer, I'm sure I was.
That he had a 1995 conviction for assault and menacing?
I don't remember individual information at this time, Mr. Delaney.
He
At
had a
the time I
2000
made the plea offer, I was aware of the criminal history.
He had a 2009 conviction for aggravated burglary?
At the time I made the plea offer, I was aware of his criminal history.
In 2013 for possession and theft?
At the time, I was aware of his criminal history.
And in 2017, again, for possession and resisting arrest.
At the time, I was aware of his criminal history.
And you're also aware of numerous other convictions that he had from the state of Arizona.
From where?
The state of Arizona.
I don't remember that.
Okay, and Mr. Fogel, having been charged with a DF1 special offender, if he had also been charged with habitual criminal for the close to 13 prior felony convictions that he had, that would have resulted in a mandatory 64-year prison sentence.
I didn't do the math. I'm aware generally of the criminal history. I'm aware of the facts of the case. I didn't do the math. I haven't spent a ton of time on the DFs since the legislature changed the DFs. And I don't really understand the habitual process when it comes to drug felonies versus the normal cases, the normal, just regular felony charges.
You were aware that a special offender DF1, even without the habitual criminal charges, carried a mandatory 10 to 32 years in prison.
Again, I would have reviewed the criminal history. I would have reviewed the facts of the case. I would have looked at where it falls within the sentencing range.
And generally, your practice in dealing with cases, would you normally make notes or some type of documentation as to offers being made?
Sometimes I do, and sometimes I don't. In this case, I did not make any notes, and I think that's well known.
Was that intentional?
I don't believe so. I don't remember. If I don't remember whether there's notes or not, I don't remember whether I've not made notes. A lot of times things happen really fast, and there weren't notes taken.
Well, based upon your practices at the time and your practice as a district attorney and your knowledge of the law and your knowledge at that time of Mr. Fogel's history, of your knowledge that there was a gun, as your knowledge of that there was drugs, what is your best guess as to why you gave him a careless driving time served?
Objection calls for speculation.
Overruled.
What happens is a detective, so we get information. Let me tell you down and dirty. We get information that somebody wants to cooperate with the police. It can come from you, Mr. Kenny. It can come from a defendant. It can come from a jailer. It can come from a detective. We get information as prosecutors. We process that information and we tell a detective or an officer, hey, this person wants to work in whatever fashion, and can you check it out? That detective or that officer then goes to check it out. They come back to me and say, this person has good information. If they have good information and the detective vouches for that, which I don't get involved in that vouching, I actually tell the detective, like in this case or any other case, talk to the defense attorney, find out what the defense attorney's got, because they usually know when somebody wants to work. When that happens, then the detective comes back to me and says, this person has good information. I would like to try to resolve this case on a fairly decent level. And again, my speculation, that's what happened in this case, but I don't remember, because I said I don't remember. I don't have any notes. I didn't take any notes. That's my best guess.
Well, it's not a fairly decent. This is a spectacular deal that Mr. Fogel was given. Would you agree with that?
Spectacular? No, I don't think it's spectacular. He spent 8 months in county jail.
Well, this for a fact, you were aware that Mr. Fogel was on parole when this deal occurred.
I don't remember that part.
You did this deal because you had to do a traffic misdemeanor in order for his parole not to be revoked. That's why you did this deal, isn't it?
I don't remember that as part of the deal.
That's the only sense, because otherwise you would have done a felony conviction with probation that would have required his ongoing cooperation. But the only way to get him out of the jail was to level this to a traffic misdemeanor.
And I don't remember that. And the fact of the matter is that people on probation aren't allowed to work either. So
Well,
whether that's the case or not, I don't remember why this disposition was done. I
And-
remember there was information potentially, as I said, the way that it normally comes in. When I look at it from sort of a 500-foot view, he must have had good information and he got a disposition.
and do you know if he had an ongoing obligation to continue to give information?
I do not know that. When somebody's sentenced, then I don't deal with them.
Well, but that would make sense, why you would be wanting to get him out so he could continue to work as an informant for Detective Kruger.
That's a question for Detective Kruger, not me, Mr. Tillane.
I'm
I
at-
know that.
I'm asking you, was that the purpose?
That's a question. I cannot answer that question.
You cannot or you won't?
I cannot because I don't know.
You were present for the plea in this matter?
I was. I reviewed the transcript.
And that would be the reason why you would approach, because you don't want to say in open court that someone's going to be acting as a confidential informant.
Typically, that happens frequently because when you put that stuff out on the record, it puts people in danger.
When you approach in that manner as a person who's been practicing law close to 30 years, usually when you ask to approach, the judge asks if you would like it to be part of the record or recorded. Correct?
Usually that happens.
In this instance, it was not.
It was not part of the record. I don't remember whether he asked or not.
And you're also aware that somebody who is on parole cannot act as a confidential informant without direct approval of the head of the Department of Corrections.
First off, I wasn't aware he was on parole.
You made, as a district attorney with close to 30 years experience, you made a decision to plead a special offender DF1 to a careless driving, and then at the time that you did it, you were stating under oath you were unaware that Mr. Fogel was on parole.
I didn't say I was unaware. I'm not sure whether I knew about it or not. I didn't know whether he's on parole at the time.
And you, again, have no idea why you made this plea offer in this case?
I told you why I thought it was made, but I don't remember independently why the plea offer was made. I don't remember if Detective Kruger came to me and said, I've got a guy that's going to give us all sorts of guns and drugs. I don't remember that.
Well, he would have had to done,
Good information, and that's why the plea offer was made.
there would have been, it would have had to be something substantial for you to let a man out who was looking at the rest of his life in prison, that Mr. Fogel clearly was promising something pretty spectacular for you to give the green light on Detective Kruger and let somebody out on parole who has a violent history to roam our streets. Would that be correct?
I said before, it must have been good information.
Mr. Lindsay, isn't that why you made no notes? Because you knew at the time you were violating DOC policy in authorizing Kruger to make Anthony Fogel a CI. And that's why there's no documentation. Isn't that true?
That is not true. I made no notes because I was rushed and things happen and we do plea agreements all the time. And there were no notes made.
You're aware that there are very specific rules regarding parole and when people are charged with weapon by previous offender.
Mr. Tillane, I'm not familiar with the rules and regulations of parole. I'm not familiar with the rules and regulations of DOC. So my answer to your question is no, I'm not aware of that.
You're unaware that it's a mandatory hold for somebody with a possession of weapon by previous offender because of the evidence that we have of the dangerousness of individuals like that. You're
When
saying
they're
you're,
convicted, I'm aware that they are mandatorily held in jail. Anytime there's a firearm used and there's a conviction that involves a firearm, whether it be murder, whether it be felony menacing, whether it be palpo, I am aware that the court revokes bond and holds them without bond.
and so you're aware of the dangerousness of anybody who has been prohibited from having a weapon who continues to have weapons. That is a dangerous person. You're aware of that. After Mr. Fogel was released by a deal that you made, you're aware that he killed 2 people.
I'm not aware of that until I was told that I was part of this case. I wasn't aware of that. If you recall, I told you I left at the end of October.
Sure, but you didn't hear nobody reached out to you and said, that guy that you let loose just killed 2 people?
No, at that time, I'm in Pueblo DA's office, working, carrying a docket, handling upwards of 150 cases. I didn't pay attention to what's happening in Fremont County.
Under the Victim Rights Act, have you made the family of Ryan Roth aware that the only reason Anthony Fogel was out to kill their son was because you let him out?
Objection, relevancy.
Goes to his claiming that he has no memory, and also whether he's complying with the Victims' Rights Act. And also, I think the families need to know that the only reason their kids are dead is because Mr. Lindsay scooted the rules, let this dangerous person out, and now their family members are dead because of a choice that he made. No further questions.
Any cross-examination? Ms. Owens?
Just a few questions, Mr. Lindsay. You testified that you were in this office in 2021 from January to October,
That's correct.
and then you left to work in the district attorney's office in the 10th Judicial District around end of October, beginning of November of 2021.
I think my first day was November 3rd.
And you were in the district attorney's office in Pueblo from the beginning of November of 2021 until the end of October of 2024, correct?
That's right, about almost exactly 3 years.
Do you remember all the plea agreements you entered into 5 years ago?
I don't.
But even with 100 to 150 cases, would it be fair to say that, it's hard to remember any one particular case unless it's a major case?
I think that's a fair statement. I prosecuted thousands upon thousands upon thousands of people in my career.
Thank you. No further questions.
This motion eliminate in and of itself, I think is further example of this district attorney's office not understanding the importance of impeachment and impeachment material. The fact that Mr. Fogel was not making control buys from my client is not in question. The fact that he was actively acting as a confidential informant at the time of the homicide is. And despite, I would say that I think that was fairly clearly shown through the testimony of Detective Kruger, despite the fact that he kept denying that. I think it is, we can hear from Mr. Lindsay that he has speculated the reason why he would have made this deal was for Mr. Fogel to get out and act as a confidential informant. One of the detectives actually puts forth the idea, I think the exact quote is, Anthony, we don't really think you're a murderer. We don't, believe all the rumors that these lesbians hired you as a hitman. We think they probably got you into this, brought you up there, and then something happened, and it was a mistake and an accident, which turns out to be the exact thing that in Mr. Fogel's proffer here that he states. There were 2 different guns. One is a .40 caliber ammunition. Mr. Fogel has stated in numerous statements to both Brandy Fogel and Danielle Hall that he shot Mr. Roth with a Cal-Tec 40. He has made statements in the proffer that they have adopted for him to testify to, that Ms. Gorilla somehow had this Cal-Tec 40 and was just firing randomly in the air. He has consistently stated that is involved. Other people have stated the Cal-Tec 40 is involved. When Mr. Fogel is arrested and being held by the FBI, he has that Cal-Tec 40. That is what he is arrested on. That gun has never been tested, and that gun is now missing. That gun is likely the murder weapon, is never compared or contrasted to anything going on here, and it is gone and missing, and there is no report that we know about that or what happened to it or why it was not tested. He is threatened in Las Vegas by the FBI, stating if you don't come and start cooperating, we are going to take these charges federally, that you're going to be looking at a mandatory 12 years federally and have to do 85% of that. That has not been disclosed until this video was finally provided to defense. All of the federal dealings are highly relevant to what is going on because Mr. Fogel is receiving double benefits. He's receiving benefits from the FBI and he's receiving a time served offer from the district attorney's office for killing 2 people. And lastly, number 5, this description, that Mr. Fogel in these jail phone calls, after he was arrested and set up by Ms. Hamilton, that he is expressing ill will towards her is the most I'm saying is deceptive to the court. What he said to Brandy, a witness who refuses to come to court, refuses to testify, has stated Mr. Fogel has confessed to her to killing one of these people and is avoiding process and avoiding subpoenas. He stated to her he needs to bond him out because he's going to kill that bitch. He's going to find her when she drives up the light. He's going to kill her and a driver. Whoever's driving her, they're going to die too. Brandy tries to get him. This is before the case goes federal and he's trying to make bond. And he's saying, when I make bond, I'm going to kill her. Brandy says, stop talking about it. He says, I don't fucking care. Blast it on Facebook. That bitch is dead. He continues throughout those phone calls to try to get Brandy to kill her. One time Brandy tells him Miss Hamilton asked for a ride. He said, and she said, no. He said, what's wrong with you, dumb bitch? Go get her and kill her, is what he is stating. It is relevant to Mr. Fogel's nature. It is relevant to Mr. Fogel's violence. It is relevant as to why neither Brandy nor Danielle Hall will testify, why they are scared, why they are running, because they have both stated to law enforcement numerous times, we know if he testifies against us, he will kill us. And it is highly relevant. And to pass this off as ill will and try to represent to the court as ill will violates the rule of candor to the tribunal. This is not ill will. He is planning on killing her once he gets out, and he is adamant in phone call after phone call that he is going to do that. And so that is highly relevant. We have him on a phone trying to arrange the murder of a witness. First, a witness who was on a state case, and then a witness who was on a federal case. And neither the state nor the federal.
And real quick, Ms. Owens, I'm not going to see that type of behavior.
I'm sorry.
Thank you. Go ahead, Mr. Tellini.
And neither the state nor the feds choose to charge him with that. I've been doing this 30 years. I practice both state and federally. I can say as a general rule, the federal government treats threats to kill witnesses incredibly seriously. And the fact that this, until I noticed this, and again, buried under everything, that this has been hidden from us, there is no explanation for it. It is, again, a pattern in this case of them hiding exculpatory information, and they know it's exculpatory, and they know that this harms them, and it's been hidden.
I believed that I thought that we had discovered 21 CR 1 or 22 CR 151 to the defense. I'm surprised that the defense is claiming that they're only now being made aware of this case, because I thought that we had discovered that information. So I find it surprising that the defense is claiming that they're not aware of it.
When was it disclosed then? You're indicating it was disclosed. When was it disclosed?
And I think I may have confused 151 with the U-Haul case, Your Honor. And it doesn't look like we discovered 151, probably because I had it confused with the U-Haul case. So yeah, it looks like we might not have discovered 151.
Is there anything that stood out to you about that?
The thing I guess that stood out the most is the incredible plea offer that resolved that case. Very serious charges, mandatory prison time, and a plea to a traffic misdemeanor. Careless was I would say, extraordinary, virtually unheard of.
Is this something that if you got this type of deal for your client that you would remember even years later?
I would certainly remember something like this. I think it's an extraordinary deal, and if you get it, you're going to remember it.
You looked at the probable cause affidavit in 21 CR 60.
I did.
Did you see any problems with it?
No, it looked like a pretty solid case. No search issues, particularly good reason to stop. I didn't see any prosecution problems with the case. It was mostly a cop witness.
And generally in your, expertise, when you're dealing with a drug case, a possession with intent, special offender, primarily, one of the main things you're looking at is whether or not there's a search issue.
Correct.
And in this case, because Mr. Fogel threw the bag with the drugs out the window, he would not have any issue with that because it would be abandoned.
That's it. That's correct.
And so there did not appear to be, in your expert opinion, any search issues, any witness issues, or anything based upon the facts of the case that then would have justified the type of disposition we have here.
Not that I saw.
All right, thank you, sir. Not only my argument for a special prosecutor, but I am actually asking for the sanction of dismissal for the numerous discovery and ongoing discovery issues that we're having in this case. This court is aware of the longstanding history of this district attorney's office disregarding their ethical rules under 3.8, under candor towards the tribunal, under Brady, under the Colorado Constitution due process, under Rule 16. Your Honor, on December 30th, 2025, made very specific findings in relation to the Clark matter in a very similar type of circumstance where this district attorney's office continues to hide exculpatory information regarding their witnesses. Your Honor found Mr. Lindsay himself in violation of Rule 3.8. There were sanctions. Your Honor listed all the numerous cases that there have been sanctions for discovery violation in this county by Mr. Lindsay's office. They're very well detailed in the transcript that I provided to the court. And the issue is nothing works. And I would note, Your Honor, the standard the court is making findings of facts here is by a preponderance. And the court has to look at, by a preponderance, is it believable that Mr. Lindsay has no remembrance of this agreement? And I would say no. So quote from the movie The Outlaw Josie Wales, "Don't piss down my back and tell me it's raining." Him getting up there and continuing to say that he has no recollection, does not know why, defies reason and common sense on this type of deal. This deal of a careless driving on these charges is so far out of whack, it is unbelievable that he claims he does not do it. And the fact, I say that Mr. Lindsay does have a personal stake and that he is trying to hide the reasoning behind this deal and that he is trying to hide the fact that he made a decision. If you get somebody who is in jail on a parole hold, facing the rest of their life in prison, to give him a get out of jail free card on a careless driving, and that person who he let out of jail went and brutally murdered 2 people, that he has a direct link in that chain, it's arrogance. It is arrogance that I'm the district attorney and no matter what I say, how unreasonable, how illogical, you've got to believe me, is arrogance. And it's the arrogance that Mr. Lindsay thinks the rules don't apply to him is why we've got 2 dead people.
Your Honor, with regard to sanctions, the people would note that People versus Whittington, trial court must strike a balance by imposing the least severe sanction that will ensure that there is full compliance with the court's discovery orders, quoting People versus Tippett, that the court should generally avoid severe sanctions, such as excluding evidence or dismissal, because these are drastic remedies. For example, exclusion of evidence may affect the outcome of the trial, provide a windfall to the party against whom the evidence would have been offered, or otherwise hinder the search for the truth. Dismissal is an even more severe sanction than exclusion of evidence. So we would submit that Whittington should be the court's lodestar to look at in issuing any sanctions in this case. We would definitely submit that dismissal is an extreme sanction that should not be imposed. The statute 20-1-107 sets forth only 3 grounds for a court to disqualify a district attorney in a particular case.
The FBI was intrinsically involved in this investigation, and specifically, Agent Walter has been intrinsically involved with Mr. Fogel, who, again, they have stated is a critical and important witness to them.
I need you in front of a mic,
yeah.
Mr. Tolini. I'm sorry. That was the hearing in question where I had to get special speakers to hear you on the recording. So
He is clearly intrinsically involved with Mr. Fogel. I cannot think of any other rational explanation as to how or why Agent Walters was alerted within an hour after Mr. Fogel's arrest in Las Vegas. And again, this has only been discovered 2 weeks ago when we finally actually got the video. There was quite a bit of discussion about him working for him, about how whatever he said to them could be beneficial, that it'd be beneficial not only in relation to the double homicide, but in relation to any federal charges that he was facing in Nevada. And then we have 4 days after that, we don't have any documentation about any other agreements, what happened, but that not only were federal charges that were threatened not filed, but the case in Nevada was dismissed. The scope of cross-examination is not just limited to questions that Ms. Owens would ask, but rather their role in the investigation, and they're specifically hiding their role in the investigation. Specifically, what happened to the murder weapon? Why were the charges in Nevada dropped? What else has Mr. Fogel done for them? And to what degree his 5K influenced that? And he basically is receiving double, triple, quadruple benefit in this matter. And the reason I also included the email from Ms. Owens to the U.S. Attorney requesting additional benefits for Mr. Fogel. One, that email started out with, I think we should just close this just to be safe. Like, that's kind of an afterthought when it's I think the court realizes how directly on point that is, that they're continuing to try to give Mr. Fogel benefit and like, let's just be safe. They continue to talk about discretionary disclosures. There is none. And the fact that there is documentation of that email, but not one email from Ms. Owens to the FBI inquiring what happened to the Caltech, inquiring why was the case in Nevada dismissed, inquiring what benefit did he get from his 5K proffer, that there's not one email asking that, shows that she is willfully violating Rule 16 and has no disregard for it.
Your Honor, I just want to address one housekeeping matter. Defense counsel keeps referring to the weapon that Mr. Fogel was found with in Las Vegas as the Caltech that Mr. Fogel referred to in his statement that he made with regard to this case. The Agent Walters' report indicates that the weapon that Mr. Fogel was found with in Las Vegas was an AK-47 chambered in 7.63 or 7.65?
7.62.
7.62 NATO. That's a different caliber than the Caltech chambered in 10 millimeter. Different weapon, different caliber. So we're not even talking about the same firearm. So I just want to make that clear.
And I would just ask if there are any such emails asking any of the questions about why this was dismissed, whether he's an informant, that if such emails exist, I'm asking those to be provided.
Ms. Owens, in regards to those email inquiries, what's the people's position as far as disclosure of those?
Your Honor, I don't think we've actually sent any emails asking why the Las Vegas case was dismissed. Obviously, cases can be dismissed for all sorts of reasons. We are happy to make that inquiry if the court deems it important, but I don't really know the relevance of that. Thank you.
Mr. Tolini? Go ahead.
I just made a record on the things that weren't done. Ms. Owens then got up and said, we made due diligence.
And then it turns out they made no diligence. This is the problem that keeps going on here, Your Honor.
All right. The court is going to take this under advisement. I will see the parties on Monday at 3:00. So I am going to grant the reconsideration. I am allowing the admission of Exhibit C only as to the discovery issues. I do agree, Ms. Owens, that under CRE 90211, this potentially would not be admissible at trial. Recognizing that certainly, and I don't think that I would find that to be appropriate at trial. We shouldn't be arguing discovery in front of a jury at trial, quite frankly. What I am finding is that at least the record before the court is not until late June was that ultimately disclosed, late June of 2026 was that ultimately disclosed to the defense, despite being ordered 5+ months prior for the prosecution to disclose that evidence. Court is also finding that that exculpatory information was provided almost 26 months after the indictment was filed in this case, after three different trial settings, and just a month before our 4th trial setting in this case. It is also of note that the prosecution announced ready on January 30th, 2026 for our March 2026 trial dates, knowing full well that the court specifically ordered that disclosure and still did not provide that disclosure despite announcing ready to the court. This court should not have to babysit discovery items. Rule 16 is self-fulfilling. Ultimately, it's self-executing. The prosecution is required to comply with both court orders and Rule 16. And to me, this is probably the largest discovery violation at this point, and an egregious discovery violation. Court recognizes that in regards to a pattern in this jurisdiction, the court recognizes that in People versus Tippett, the Colorado Supreme Court found a multiple significant discovery violations by the district attorney's office, including explicit warnings from various judges that a pattern of neglect was emerging or had emerged, a lack of understanding by prosecutors regarding their Rule 16 obligations, an apparent lack of oversight by the district attorney in the face of significant continuing discovery problems, and a pattern of the district attorney's office of dismissing cases when faced with discovery sanctions. The court then found 20 different discovery violations. This court is aware of the fact that the Tippett case was decided under a previous district attorney administration, one in which that uniquely, I don't know historically how often that has happened, but it is certainly rare, a district attorney who was ultimately disbarred, Ms. Stanley, and the court is aware that Mr. Lindsay then took office thereafter. By this court's count, at least 23 discovery violations have been found since Mr. Lindsay took office, and I am not finding that this can any longer be blamed on the prior administration in this district attorney's office. And not lightly, this court is ordering for a reduction in charges in this case to Class 2 felonies. It has to be a drastic sanction here to get the message across, because it is extremely concerning to this court that I issued a very explicit ruling on December 30th of 2025. And 3 days later, 2 or 3 days later, the court explicitly orders for discovery to be provided by the prosecution, and it's not disclosed until months later. And their obligations of following court orders. Certainly, there's a request for the court to revoke bonds, find violations of protection orders for other members of the community violating court orders, requests for contempt when witnesses don't appear on subpoenas, but then to turn around and disregard court orders themselves, it's two-faced, quite frankly. It's not justice. It's not how our justice system is meant to proceed, but also, and for if ultimately Ms. Carule is found or convicted, recognizing there's a presumption of innocence, but if she is convicted, that she can still be held accountable with the sanction imposed. I am not finding that any other sanction is strong enough at this point to ensure compliance. Court has concerns or has indicated some concerns about credibility of Detective Kruger, but did find his testimony credible as to the fact that he worked with Mr. Lindsay to get Mr. Fogel out of jail, got his specific words, Detective Kruger's specific words, got him off a dope and gun case to get him out of jail to act as a CI. That Mr. Lindsay and Detective Kruger did that work only for Mr. Fogel to turn around and be involved with the kidnapping and homicide of 2 individuals 4 months later. I don't see how else a district attorney, an elected district attorney, wouldn't have a personal interest in a case having that type of involvement. So the court is finding not only that he is a material witness, but that he has a personal interest in this case at this point in time. The court would note that there has been some concerning acts by the district attorney's office in not providing full candor to the court in this case. Court doesn't even have records that the DA's office exercised due diligence in getting these items as ordered on January 2nd, 2026. I have representations made to the court, but what's concerning to the court is that representations have been made in this case, and then information comes out that those representations were not wholly truthful. The court should be able to rely on the prosecution to comply with court orders and fulfill their discovery obligations, especially after explicit orders from the court. The court also should be able to rely on the prosecuting attorneys in this case to comply with Rule 3.3 of the Rules of Professional Conduct and their duty to provide candor to the court. As I've indicated, that wasn't just a Rule 16 obligation, but federal and state constitutional obligations to provide exculpatory material. And it's concerning to this court that this court has had to repeatedly advise the prosecution what exculpatory means, which raises extreme concerns to the court about Ms. Garule receiving a fair trial in this case. Another instance of a failure to provide full candor to the court, Ms. Owens made a record on July 11th, 2026, that the prosecution's office had no records of plea negotiations offered in 21 CR 60. Yet on July 20, and then on July 24th, in response to a court order, Mr. Lindsay filed an affidavit with the court that he had no independent recollections of plea negotiations in that case. And then somehow, on July 6th, after being served a subpoena ducis tecum, the DA's office produces a record that one of the offers conveyed in 21 CR 60 was an 8-year Department of Corrections sentence offer. So the month before, there was no records of plea negotiations, and yet in July, suddenly there is a record of a plea offer extended that was wholly different than the offer ultimately provided. The court is unsure of how much more extreme it gets when the prosecution continues to refuse or fails to provide exculpatory information to the defense, is not forthcoming with the court, not to mention allowed a detective to testify under oath to things directly contradicted by records in possession of the district attorney's office. This court has to note that this court also witnessed extremely inappropriate behavior on behalf of Ms. Owens during the original trial of co-defendant Suzette Sawyer in 24 CR 169. There was an instance in which the prosecution told witnesses who had not yet testified about what another witness had just testified to for the first time, and had to be admonished by the court regarding how inappropriate that was. Prosecution during that trial also, and recognizing that that trial is very much unique to this case as well, given that the prosecution even sought joinder with this trial originally. During that trial, the court also had to admonish the prosecution regarding how inappropriate and inflaming it was for a prosecuting attorney to get up from the prosecution table and go to the back of the courtroom to sit with members of the victim's family and hold their hands during defense cross-examination of witnesses. Prosecution also had a detective testify at that same trial that Anthony Fogel had no obligations to him at the time of the homicide. That detective being Detective Kruger, despite signing a confidential informant agreement less than 4 weeks prior to the homicide. a document that was within law enforcement possession. The prosecution was aware that Detective Kruger wrote a report in December of 2025 saying that all confidential informant or CI work with Mr. Fogel or communication with Mr. Fogel wasn't around the time of the homicide, while the prosecution was in possession of cell phone records indicating hundreds of text messages and phone call conversation with Detective Kruger and Anthony Fogel around the time of the homicide, to include a phone call the night of the homicide and a phone call a week after the homicide, while Detective Kruger went to meet with Mr. Fogel and an FBI agent, Walter. Detective Kruger also testified to the fact at that trial, testified that the Holiday Inn operation in August of 2022 had nothing to do with this case and was totally unrelated, despite the district attorney's office knowing that co-defendant Fogel had made statements about this homicide during that investigation. However, the court is finding we are not just dealing with discovery violations. We are dealing with a lack of full candor to the court, a failure to comply with the rules of professional conduct, specifically rules 3.3 and 3.8, inappropriate behaviors by the district attorney's office, a district attorney, the head of the district attorney's office being a witness, a critical impeachment witness as to a co-defendant and critical witness for the prosecution, and having personal interest in this case. I am also finding that the favorable treatment of Mr. Fogel twice by Mr. Lindsay in this district attorney's office, despite him having multiple violent prior felony convictions, while extending no offers to this co-defendant and having extended also a favorable offer to co-defendant Sawyer, is further evidence of the fact that the defendant is unlikely to receive a fair trial in this case. This court also has to consider that Exhibit 1 of Defense 10 motion shows that the prosecution has even attempted to get more favorable treatment of Anthony Fogel by emailing the Department of Justice to see if Anthony Fogel could serve his federal sentence in state court. That email being from March 20th of 2026, after Mr. Fogel's plea in 24 CR 168 was offered to the court without this information on March 6th of 2026. The court would also note Colorado Revised Statute 167301 subsection 3, in which defendants whose situations are similar should be afforded similar opportunities for plea agreement. I am going to recognize that the prosecution has full discretion in making plea agreements, but I'm also finding that that is contradicted somewhat in this case and the authority in that statute when no offers have been made in this case and 25-year offers have been made to the co-defendants, one of which is concurrent to a substantial federal sentence. I wouldn't expect that that statute requires the prosecution to make an exceptional offer in this case, because I do recognize that one co-defendant already went to trial that resulted in mistrial, and the other co-defendant agreed to cooperation with the prosecution to get that benefit, but no offer at all does lead further credence that Ms. Gruley is being treated extremely different by this prosecutorial office. So I am granting the motion for a special prosecutor. I am disqualifying Ms. Owens, Mr. Tommy, and the entire 11th Judicial District Attorney's Office because the head of the office, Mr. Lindsay, is a witness in this case. And based on the actions of the prosecution up until this point, this court no longer has faith that Ms. Gruley would receive a fair trial. This court finds this is appropriate to ensure the integrity of the fact-finding process, the fairness and the appearance of fairness of this case at trial, and the orderly and efficient administration of justice and the public trust and confidence in Colorado's criminal justice system. I think in rendering that order, it would be inappropriate for the court to rule as to the motion to exclude the FBI witnesses. The court will be prepared to rule on that motion once a new prosecution has been appointed and can address that motion. I do think that stays all proceedings at this time. I am not finding that a special prosecutor would be able to get up to speed in this case I know the defense has referenced a number of times of the large, voluminous nature of discovery in this case, and certainly a special prosecutor would need time to get up to speed with that. So I am vacating the trial currently set for July 27th. Again, not finding that it would be fair to require a special prosecutor to be up to speed by that time. And I think the case law supports a stay in proceedings until that special prosecutor is ready to proceed ultimately with trial. I also want to make sure it is clear that it is this court's utmost responsibility to ensure that both the state and federal constitutions are followed in this courtroom and that the defendant receives a fair trial. To not do so would not be upholding said constitutions and would ultimately subject this community and the victims' families to years of appeals, potential reversals, and potential new trials. And at least in my experience, it is much more challenging to try a case 10 years down the road than it is to try a case 2 or 3 years down the road. So I want to make that clear. I recognize that this delays proceedings and that a reduction in charges is an extreme sanction here. I recognize that. I just don't know how else the court is going to get compliance with discovery obligations and Brady obligations. It's not a decision this court made lightly. Quite frankly, this court struggled over the right decision all weekend long and had worked on this all weekend long.